DC 2103104, and this is Jib Zaley for the plaintiff.
Okay. Opposing counsel?
This is Karina Loya, representing defendants Theodis Thomas and Liquid Environmental Solutions of Texas.
Okay, let's proceed.
All right, thank you, Your Honor. Your Honor, we're here on our motion to strike the controverting 18.001 affidavits filed by the defense. We've got a number of them filed together in this motion because they share in common the deficiencies that we believe make this strike warranted. I will use Dr. Charda's report as an example. As the court knows, In re Allstate really changed the landscape on these 18.001 affidavits. And what we're really looking for is fair notice from the controverting affiants. So in this case, we look at the opinion from Dr. Charda. Your Honor, may I use the screen share?
Okay, let me enable that. You got it?
Got it. Thank you. All right, so in this case, we see the ultimate opinions from Dr. Charda kind of summarized in this chart right here. And we have the CPT codes, data service, description of the procedure, the amount billed, and then what's ultimately his opinion is what is a reasonable charge. In this case, 240 and 195. So what the controverting affiant needs to do is provide fair notice for this opinion, what his reasonable charge is. So we go then to the content of the affidavit to see what bases were provided. And here's what we get. His statement that he's analyzed benchmark data from Fair Health, Medicare, Texas Department of Workers' Compensation Division, and in-network health insurers. Okay, great. Which one of these was relied on to generate what was a reasonable charge? Well, that we don't know. Was it a combination of these, or is it relying on Medicaid, Medicare, Texas Department of Insurance? We don't know. All we get is this discussion that all these various sources were cited and then the ultimate conclusion. But the basis for that conclusion is what's missing. This would be as if I had sat down here today, Your Honor, and I had said, I have looked at cases from other judges. I have looked at cases out of the Fifth Court of Appeals. I've looked at cases from Tarrant County, and they all say that these affidavits should be struck. Opposing counsel very rightfully would like to know what cases, what judges, where is any of this coming from? Instead, I just get the most bare assertion that a lot of databases have been referenced, a lot of data has been analyzed, but none of that is provided to us. We just have to guess at what was actually used to reach the opinion. This is not unique to Dr. Charda. This is common in all of the affidavits today. They all give us what they claim to be the reasonable charge, tell us they reference these same sources, that they looked at the data, but then we don't get any of it. And I think for controverting affidavits to survive in this day and age, they need to do a little bit better than that. If they're checking their data, all they got to do is give us a copy of what they're checking. It would be required in the expert disclosure rules for notice. It should be required in the 18.001 analysis as well for what means fair notice. Thank you.
Response?
Yes, Your Honor. As counsel has stated, In re Allstate has changed the landscape of reasonable notice, and it is comparable to the pleading notice requirement, which is it's pretty standard, clear, and concise. And defendants believe that we have complied with the reasonable notice standard as set forth in not only 18.001, but also in re Allstate. And I would like to kind of bring the court back to that decision, to how it determined reasonable notice as it pertained to the RN at issue in that case. And it states, and I'm reading directly, and I can share my screen if the court likes. Let me see. I do have that ability. So Here it goes to section 18.001 does not define reasonable notice, but its meaning is similar to the fair notice requirement. And it goes here and talks about her counter affidavit and how it, explains in detail the basis of which she and Allstate challenged the reasonableness of the medical expenses. So primarily what the court looked at was her comparison of the charges, which defendants counter-affiance have done and counsel has displayed to this court, with the median charges for those services during the same time frame in the same zip code, according to Context for Healthcare database. It appears that RN Dickinson solely used that in addition to her experience, mainly because she was an expert in coding. Our experts here in this case are not experts in coding, however, they are doctors. They regularly look at these expenses, these fees, these services, these exact same services that plaintiff underwent with these medical providers, and are the ones that are charged with the duty to pretty much require a certain charge for that specific CPT code. And so if I go back to what counsel showed the court, which looks like is this one is specifically, it's also Dr. Sharda, but it's a different provider. So the services and the CPT codes are a little longer. You have here, it's boiled down by the data service, CPT code, the description, the amount billed, and what they are determining to be reasonable charge. I also want to bring the attention to this court that 18.001 does not require, nor does the case law in Ray Allstate specifically require defendants or the counter-affiance to provide documentation. What counsel is trying to, the standard that
Is she freezing or is it my computer?
I think Ms. Loya is freezing.
counsel is trying to impose on the counter-affiance. Am I frozen?
You'd froze for a second.
Okay, am I good now?
Yeah,
Okay.
you're frozen again. It's been one of those days.
I was saying that what this has. Okay, hold on one second.
But let me just say this, Mr. Zaidi. I respect what you're doing here, and I think it's admirable. What I wonder about is I've made I know a number of rulings. I think one or two in your favor. Have any of those been taken up to the Dallas Court of Appeals yet?
The ruling in the Gwen Oliver versus Juan Cuellar case went up to the Court of Appeals, and they just affirmed your decision to exclude the providers in that case. And Justice Peterson,
To exclude it, or was this a situation where I granted the motion to strike?
that was a Daubert motion, so that was a little bit different.
Okay, so have you had anywhere that they ruled on, not just for me, but for anybody on this motion to strike issue?
Not yet, Your Honor.
None of those have been appealed?
No, Your Honor.
We apparently have two Miss Loyas, one who's frozen and one who's a
Yes,
picture.
I got on my phone to do the
two Miss Loyas, one who's frozen.
voice.
Now you have feedback.
Okay, there we go. I disconnected my computer audio.
Okay. All right.
I think I
So
can
anyway,
continue.
what I was getting at, Mrs. ID, is I guess, you know, you're taking your shot here. I'd kind of like to see what the Court of, before I rule on a bunch of these, I'd like to see what the Court of Appeals is going to do and give us a little more direction, because in Ray Allstate, I mean, I think left open a lot of interesting questions. And so this Court of Appeals hasn't ruled on any of these motions to strike. Have they had any opinions on an appeal of a motion to strike since in Ray Allstate?
I had one get appealed, but there was no decision made. We ended up settling before it came out. So, so far, nothing.
When is this case set for trial?
We have some time ahead of us, Your Honor, and we're probably going to need to ask for more time since we just added a new party to the case.
What's
I
the
think it
cost
was
number on this?
December, right, Chip? Is it December of this year?
Oh, actually, I'm looking at it right now. It's actually March of next year, so we still have quite a bit of time ahead of us. We may not even need the extension.
Yeah, what I would suggest we do is let's just hold off on a decision until I'm not going to grant or deny the motion, and let's raise it again closer to the day of trial when we have a little more guidance from the Court of Appeals on this. I've made a couple rulings that are appealable at this point, and I don't want to have 20 of them go up. And because I think as much as I agree with you on a lot of this, Ms. Eddy, I don't know how the Court of Appeals is going to, especially the Supreme Court, is going to rule on this stuff. So I would prefer just, especially also Ms. Loya is having quite a few technical issues, unfortunately, as I have today as well. So I would say let's just go ahead and just delay it, but unless there's some strong reason to get a decision now on it.
No, Your Honor, I can agree with that. That's fine.
Ms. Loya, how
We're
do you feel?
okay with that as well.
Okay. All righty. Anything else, guys?
That's it from plaintiff.
That is all, Your Honor.
All right. Good luck with your computer, Ms. Loya, and you guys have a great day. Okay.
You too. Thank you.
Thank you, Your Honor. You take care.
Thank you. Tony, I'm not sure when we're starting the next hearing, so if you don't mind just staying on, I need to talk to Ayanna a little bit longer. So if you could just wait on here, or I can text you if that's easier. Tony, you're muted.
I was actually going to be in another room doing something. I can hear you when you start back up.
Okay.
All right. Okay.
Oh, let me go ahead and turn this off.